If you're about to invest in a small or mid-sized business, your friend's company, local operator, fast-growing service business, here's the truth. Investors usually don't lose money because the business is actually bad. They more often lose money because the deal is just poorly structured, or it's undocumented, or it's unenforceable. So in this video, I'm going to walk you through 8 legal checks that I want every investor to run before you invest in a small or medium-sized business, or SMB. Let's start with the most basic question that causes the most confusion. Equity versus debt. What did you actually buy? Before you invest in a business, ask this: am I buying ownership or am I lending money? Because if your paperwork doesn't match your understanding, you may discover later that you bought kind of nothing that's enforceable. Equity is you owning part of the company, LLC units or stock. Debt is the company owing you money, like in a promissory note with repayment terms and remedies. Let's look at the real world example. I've seen a $75,000 investment into a local contracting company where the investor thought it was a loan. Monthly payments were discussed, but the only document was actually just a 2-page acknowledgement. When revenue dipped, payments stopped, there was no note, no maturity date, no default terms, no collateral. The investor spent more money fighting about the structure than they ever could have earned. Here's how you should navigate that. You should be able to say in one sentence, I bought X percentage, or I loaned a certain amount of money at a percentage due on a certain due date with some kind of security that's collateral. If you can't describe your investment in one sentence, you're not ready to wire funds. Now that we know what you're buying, let's talk about who's already ahead of you. This is where we get into the cap table and the existing obligations. Who's ahead of you in line? You can negotiate a great deal and still be behind 3 invisible deals that you didn't even know existed. So before you invest, you need to know who owns what and who gets paid before you. Ask for a cap table or an LLC membership schedule and a list of all debt, liens, and side agreements. We'll go to the example of an investor who put money into a construction services business expecting 10% ownership. Later they learned an early silent partner had a handshake promise for 20% that they didn't know about. The company had a merchant cash advance with daily pulls, which is not good. And a prior investor had a convertible note converting ahead of everyone. The new investor's stake was diluted and the business's cash was actually already spoken for. So how do you navigate that? Well, you got to request the cap table, membership schedule, all notes, safes, convertibles, options, all debt, all liens, and any profit share or management fee arrangements that already exist. If ownership and obligations aren't crystal clear on paper, you should actually just assume that there's hidden risk that's baked into your deal. Next, let's turn to due diligence, where most investors kind of underscope the risks that actually end up killing the deal. Due diligence that matters is not just a send me the financials email. If your due diligence is send me the financials, you're really not doing due diligence. You're kind of doing optimism. The goal is to find deal killers before they find you. So let's talk about the core diligence buckets that these fall into. Number 1, we're always going to start with contracts. That's going to be your top customers, your vendors, your leases, your loans. Next up, we got claims. Are there any lawsuits, disputes, or even sometimes regulatory issues out there? Then we got employment. You have misclassification between W-2 and 1099s. You got wage exposure. You got key employee terms. Then we go to IP ownership, which is your brand, your code, content, customer lists, and finally compliance, licenses, permits, privacy, that type of thing. I'll give you guys the example of a buyer investor who loved a commercial cleaning company. Great margins on paper, as they do. But 60% of revenue came from one contract that was terminable on 30 days notice. I mean, think about that. The client changed vendors 2 months later. They had great financials, but a fatal contract term. So how do you navigate that? Don't ask for everything that's just too much. You gotta ask for what can kind of break you fast. It's gonna be top contracts, debt, litigation, payroll classification, IP ownership. Diligence isn't about feeling good, it's really about discovering what can break your deal. So once you know the risks, the next question is, what rights do you have to prevent those bad decisions? That's what brings us to governance and control. What rights do you actually have? Common investor regret I hear all the time. I invested real money and had zero say when they made terrible decisions without me. That happens when the rights aren't negotiated up front. Think about this. Even minority investors often need information rights. We're talking financials, KPIs, bank statements. You want approval rights. That's if they bring on new debt, big purchases, paying insiders, or asset sales. If you can get board or observer rights, even better. And then you have protective provisions, which can limit dilution, which is great, and related party transactions, kind of insider dealing. So here's an example of this. An investor funds, let's say, a restaurant group expansion. 6 months later, management signs a new lease and starts paying insiders consulting fees, and that drains the cash down. There are no distributions anymore, there's no visibility, there's no consent rights. The investor can't stop it because the documents never required their consent. So how do you navigate that? Well, in LLCs, they typically live in an operating agreement, and in corporations, they're going to usually be in a purchase document or in a shareholder agreement. If your only right is to hope that management behaves, you didn't negotiate the investor protections the way you should have. Now let's talk about the part investors focus on, but often misunderstand. How do you actually get paid? These are the economic terms. Not only how do you get paid, but also when do you get paid. A lot of SMB equity deals are secretly donations because the investor never asks, how do I actually get paid? And what's the path to payment? You gotta understand those two things. Returns usually come from distributions, a sale, if it's debt from repayment, or conversion if it's convertible. Let's look at this example of an investor that buys 15% of a profitable landscaping company expecting a profit share. But the operating agreement lets owners increase salaries and vehicle allowances first, so profit kind of dwindles down to whatever's left after all the insiders get paid. The business is thriving, but the investor still never sees a dime. So how do you navigate that? Well, you need to clarify a distribution policy, mandatory versus discretionary, what counts as profit, put some guardrails on those insider compensation deals, and who gets paid first on a sale, which is your preferences. If there's no clear mechanism for returns, the investment thesis is really incomplete. And even if the economics are solid, you still need one more reality check. How do you get out? This is exit rights. Can you get out, or are you going to be trapped in this thing forever? Assume this, you'll want out earlier than you think. In SMB deals, your exit is not a market, it's a contract. You need to understand transfer restrictions, right of first refusal or ROFR, buyback rights, put-call options, redemption mechanics, and what happens on death, divorce, and insolvency. I know it sounds odd, but it comes up all the time. I'll give you the example of someone investing into a software agency that's structured as an LLC. A year later, they want out, but the operating agreement requires manager consent for transfers and has no buyout formula. The only offer is, we'll buy you out later when we can, which kind of means never. So how do you navigate that one? Negotiate a real off-ramp, which is a buyout formula that's tied to something like EBITDA, installment buyback, or a defined process if a third-party buyer does appear. I guess what I'm trying to say is if the agreement actually doesn't give you an exit path, you should just assume you're going to be locked into this thing indefinitely. Next is the compliance issue, which most small investors ignore until it becomes a more serious legal problem in securities law. So, securities law, yes, this does still count. If you think securities law is only for Silicon Valley raises, think again. Many SMB investments are actually securities transactions, and sloppy compliance here can create real liability. These key issues are going to include exemption eligibility, investor qualifications, required disclosures, and sometimes even state and federal filings. Let's look at an example of a real estate development company that raises small checks from, we'll call it 25 friends and family or friends of friends, with kind of vague participation agreement and these pretty rosy projections. The project underperforms, and investors demand rescission, which is a return of their money, arguing that the raise was improperly offered and underdisclosed. So now the company's fighting both economics and compliance exposure. How do you navigate that? As an investor, you want reps that the offering is compliant, that you received material disclosures, and that prior raises weren't mishandled. Even simple raises can create securities exposure, so make sure the deal is properly papered. Finally, let's talk about what separates professional deals from amateur ones. Now we come to enforcement if things go wrong. Oh, enforcement. If things go bad, what can you actually do? This is what everyone should be concerned about, but somehow never is. The final question of this is, if the deal goes sideways, what can you actually enforce? Because rights that aren't enforceable, that's more like a motivational quote. If it's a loan, you're going to want to be thinking about collateral and a UCC filing, personal guarantees, default remedies, and priority versus other lenders. Let's look at the example where an investor is loaning $150,000 to a trucking business on a note with no collateral and no guarantee. That's a danger zone. Later, the company can grant a secured lender a blanket lien on all assets, and when things fail, the secured lender gets paid first, and the investor is effectively unsecured. It's a bad place to be. Now, if it's equity, focus on information rights, consent rights, dilution protections, and limits on insider transactions. The best time to build downside protection is actually before you send the money, never after. If you're investing in a small or mid-sized business, just remember this. Good deals don't rely on trust. They're going to rely on clear terms and enforceable documents. If you want, go ahead and reach out to me and I can share a practical diligence checklist that you can use before investing, or you could bring it to your attorney and kind of pressure test the deal. That's it for this one. Keep watching these videos for more guidance for founders and investors.